In today's lecture, we take up the question of the documentary sale. Now, everything that we have studied so far has been about managing risks. That's the focus of this entire section of classes, managing risks. And in this lecture, we'll learn how those risks can be managed to permit the transaction of international business transactions at long distance. Now, previously we've discussed how international trade involves risk. There's always a risk involved in international trade. Now, the form of the risk may change depending on what is at stake. In general, though, as we discussed early on in this section, there are two broad categories of risk. One of which is performance risk, and the other is transactional risk. Now, when we were discussing performance risk, we talked about things like non-performance, which in the case of a commercial sale of goods would be a seller who doesn't ship goods or a buyer who does not pay. There are other forms of performance risks, things like late performance, a seller who ships goods after the contract date, or a buyer who pays after the contract date. There's early performance. There are certainly a number of things that could occur in terms of performance. Now, the second type of risk, transactional risk, involves things like acts of God and acts of war, and simply the things that relate to issues that could occur when transferring goods over a long distance. So businesses use contracts to manage risks. So today what we're going to do is look at the risks involving performance of the obligations in a contract, and we're going to study the legal structures that have been created to minimize those risks, to permit the sale of goods and the payment for those goods at a long distance. Now, there are transaction risks involved in any international business transaction. Transaction risk refers to the risks facing the buyer and the seller when they move money and goods in an international sales transaction. And when we talk about transaction risk, we're really looking at the barriers that separate the buyer and seller when they move money and goods. Now, these barriers that separate buyer and seller include distance, oceans, time that the goods are out of the hands of both the seller and the buyer. So these barriers will take different forms. In addition to things like distance and oceans and time, there's also communication difficulties, legal difficulties, cultural differences, national boundaries, interference by local authorities, and differing legal systems. Now, when we talk about transaction risk, we tend to break it down into two types of transaction risk. First of all, there is delivery risks, risk having to do with the delivery of the goods, and payment risks, risks that occur in conjunction with payment. Now, delivery risk is the risk that the buyer will not receive the goods. The seller will fail to ship the goods as called for in the contract, or time, moisture, storms, shipwrecks, piracy, pilferage of ocean containers, any of those could lead to a problem with delivery. Now, payment risk is the risk that the buyer will fail to pay as promised. Now, payment risk is also referred to as credit risk. Credit risk is the problem that arises in that most sellers would prefer to have cash in advance from buyers, and especially from foreign buyers. So sellers are reluctant to release their goods without having the cash in hand. Buyers would, of course, much prefer a transaction based on credit. Buyers prefer to buy on an open account, wherein the buyer typically has 30 days to pay. Domestically, most sales across state borders are made on this basis. Now, these two methods, cash in advance and the open account transaction, will pose a transaction risk to either the buyer or the seller in the international trade. So bringing them together requires some other form of payment, and that payment is going to be known as the documentary sale. So the question is, how do we manage delivery risks and payment risks in our transaction? And the answer is we use a legal process called the documentary sale. We create a document that is going to abstract the goods. And what I mean by that is we're going to create a legal document that represents the goods. You may think of it as the way a check represents money in the bank. And when I write a check at the grocery store and I hand it to the cashier, I'm only handing her a piece of paper, but what that piece of paper does is it represents the money that is sitting in the bank. So we transfer the check, and it's the same as if we transferred cash. You could also look at it as a motor vehicle. Every motor vehicle, every car has a document of title, and this title represents ownership of the car. So when we sell a car, we must transfer the title, the document of title. And whenever we talk about title in the law, what we're really referring to is a formal right of ownership. So whoever possesses the title to the motor vehicle owns the motor vehicle. So we're going to use this document of title to move goods and to transfer ownership and possession of goods. Now, documents of title are created out of a special relationship. That is to say, there's the owner of property, there is a person to whom the property is entrusted, and there's a third party. Now, in the law, we call this a bailment situation. Bailment situation refers to a situation in which the owner, who is the bailor, will deposit certain goods into the hands of a bailee. You can think of it as depositing goods at a warehouse. And the process of bailment is the thing that's going to separate ownership from possession. So when we create a bailment, what we are going to do is we're going to separate the notion of who owns the goods from the notion of who possesses the goods. You could also think of it as a pawn shop. The way pawn shops work is a person deposits goods. He receives a loan in exchange for those goods. When he repays the loan, he gets the goods back. So the goods remain in the hands of the pawn shop, but title to the goods remains in the hands of the person who pawned the goods, who in this case would be the bailor. So in a bailor-bailee relationship, the bailor transfers goods to the bailee, and the bailee will provide a document of title to the bailor, and the document of title will establish ownership of the goods. Now, the documentary sale is a type of contract for the sale of goods in which possession and ownership of the goods are transferred from the seller to the buyer through a process of negotiation and delivery of a document of title. In this case, the document of title is going to be issued by an ocean carrier. Now, just as with any transaction, there are certain obligations involved. And in a documentary sale, the seller's obligation, here's the seller, he has an obligation to place the goods into the hands of an ocean carrier. The ocean carrier is a neutral third party that has no relationship to either the buyer or the seller. So the seller is going to transfer the goods to the carrier in the time called for in the contract. And in return, the carrier is going to provide to the seller a document of title. The buyer also has an obligation under the contract of a documentary sale. The buyer's obligation is to purchase the document of title. So the buyer will purchase the document of title from the seller, which will then give the buyer the right to claim the goods. So here we have the seller who has transferred the goods to the carrier. So the goods are transferred to the carrier. In exchange, the carrier has provided to the seller the title, a document of title to the goods. And in a documentary sale, the seller will now deliver the title, the document of title, to the buyer. Now, in a documentary sale, we are going to use the banking system to handle this process of exchanging the document of title for money. So rather than direct transfers between the seller and the buyer, in which the seller would provide to the buyer the title and the buyer would provide to the seller payment, well, that can be complicated as well. So in order to have this actually occur, instead we're going to use an indirect means of the seller will use its bank and the buyer will use its bank, and the banks themselves will handle the exchange of the document of title and the money, so that the buyer and the seller are freed from that responsibility. Now, in this next section, we're going to talk quickly about this document of title, which is referred to by the legal term bill of lading, because this bill of lading has some special provisions that separate it from an ordinary document of title. A negotiable ocean bill of lading is a document of title. Now, this is a document of title that an ocean carrier will issue to a seller, a shipper of goods, upon receiving goods for the transport. So a negotiable ocean bill of lading is a document of title provided to the seller by an ocean carrier. In this slide, you can see a typical ocean bill of lading in which the shipper, the exporter, is referenced. The consignee is the party to whom the goods are being sold. And down here we have a description of the goods, their quantity, and any special description of the goods. We also have down here a listing of freight charges, because the bill of lading is going to not only be a document of title, but it's also going to be a contract of carriage. And the negotiable bill of lading is a very important document, and it's important because it's really playing three different roles. First of all, it's a receipt for the goods from the carrier, indicating any damage to the goods that are in place that was visible at or apparent at the time of loading. So it's a receipt for the goods provided by the carrier to the seller, to the shipper. It's a receipt and explains what the goods are and their condition. Now, as I said, it's also a contract of carriage, meaning it is going to be the contract that governs the costs of shipping the goods between the shipper and the carrier, as well as any obligations by the parties in regards to that shipment contract. And finally, and probably most importantly, the bill of lading is the document of title to the goods that are described in it. So in the bill of lading, we separate ownership and possession so that whoever possesses the document of title has ownership, legal ownership of the goods. Now, of course, we have to have a law that governs these bills of lading, and in the U.S. it's called the Federal Bills of Lading Act, and it governs all rights and responsibilities having to do with a bill of lading. Now, a purchaser of a document of title has certain rights. A document of title can be described as either negotiable or non-negotiable. Now, the difference is that a negotiable bill of lading is a document, a legal document, that is transferred through a process called negotiation. And negotiation refers to the transfer of a document of title by its owner to another in a manner that passes title to the document, title to the goods, and the right to claim the goods from the issuer of the document. Now, negotiation is special too because it's a means of transfer that can give the transferee more rights than the transferor. Now, this is very unusual in the law. Generally, in an assignment of rights, of contractual rights, the assignee takes the same rights that the assignor had, which is to say the assignee steps into the shoes of the assignor. But when a document is negotiable, then in fact the assignee, the party who is taking the goods, can wind up with more rights in the goods than the assignor, meaning the assignee will take those goods free of defense, free of any claims on the goods brought by others. A non-negotiable document may not be transferred by negotiation. A non-negotiable document is only deliverable to the recipient that is named on the bill of lading. The beauty of a negotiable bill of lading is that the goods can be bought and sold while in transit simply through transfer of possession of the document of title. So a negotiable document of title has certain characteristics. It must be signed by the consignor. It must be a written document that is signed. It must state that the goods will be delivered to the order of a named person or to the bearer. And this phrase, to the order of, you may recognize that from your check. A check is a negotiable document of title. Or to the bearer. That makes it a negotiable document of title. Now, when we talk about negotiation, that's the transfer of a document of title by a two-step process, a process of indorsement and delivery. Now, endorsing a document requires a signature. And again, to be negotiable, the bill of lading must be written to the order of some specific party. So in this case, the party named in the bill of lading, the first party named, can transfer that title by signing the back of it through the process called indorsement, and then transferring possession of the document of title, the process that we know as delivery. Now, when a negotiable document of title is sold, the seller is said to have made constructive delivery. In the law, when we talk about constructive things, we're talking about fictitious things that have the effect of being real. So when a negotiable document of title is transferred, it is the same as if the seller actually made delivery of the goods and not simply constructive delivery. Now, the new owner can resell the goods while they are in transit. He can wait for the goods to arrive and use the bill of lading to claim them, or he can use the goods as collateral for a loan. As long as he has the document of the title, then it's the same as if he had actual possession of the goods. I said negotiation is a special type of transfer, and the negotiability of the bill of lading is what makes it so important to international trade. As the document of title is bought and sold, so are the goods that it represents. So negotiability permits merchants to trade in goods, in cargo, while that cargo is still afloat. As an example, oil brought from the Persian Gulf, which is a long way from the U.S., Persian Gulf oil can change hands 20 or 30 times in the 6 weeks that it takes a transfer, that it takes a tanker to reach U.S. waters. Now, I said negotiating a document carries with it a certain protection for the buyer. The purchaser of a document of title, if he purchases that document of title in good faith, has a special protection from risk. The Federal Bills of Lading Act gives special protection to those who purchase negotiable documents under such circumstances as to become what's called a holder in due course. A holder in due course. This purchaser, once he is a holder in due course, will have certain protections from anyone else who has a claim against those same goods. So how do we figure out who is a holder in due course, or as they are also known, a holder by due negotiation? A holder by due negotiation is someone who purchases a negotiable document for value, meaning there must be something of value given in exchange for the transfer. Now, this is usually money, obviously, but it could be other things. It could be an exchange of goods, could represent value. But it is separate from someone who acquires a document of title, say through an inheritance or through a gift. If you receive the document of title that way, you have not paid value, and therefore you cannot qualify as a holder in due course or holder by due negotiation. The second requirement is you take it in good faith. Good faith without notice of any claims against not only the document of title, but claims against the goods. And finally, it must be in the ordinary course of business, meaning it is your business to purchase these types of goods or these types of titles to goods. Now, when you become a good faith purchaser takes a negotiable document title free from any claim that a third party might have against the goods represented in the document. A good faith purchaser will get clear title to the goods regardless of any claims by anyone else. This means that a good faith purchaser, can take goods without the fear that someone else has a claim against those goods. Now, what types of claims are we talking about? Well, generally what happens is that a seller will have certain inventory. So a seller will have inventory in its business. And what the seller will do is the seller will arrange financing from its bank. And the bank will provide the seller with money. In exchange, the seller will give to the bank an interest in the goods. And this is called collateral. So the seller will give to the bank an interest in its inventory. Now, the seller may well sell those goods to a buyer, even though the goods are subject to the bank's interest in the inventory. The seller can transfer the goods to the buyer and refuse to pay the bank. The seller can keep the money for itself. Well, if the buyer is a good faith purchaser, we're also known as a bona fide purchaser, a BFP, then the buyer acquires title to the goods and the bank loses its interest in the goods. The goods are transferred to the buyer. Now, the bank still has rights against the seller for repayment, but the bank does not have rights against the buyer of the goods. The buyer takes those goods free of any claim from the bank. Now, this was the fact pattern in the case in your book called Banque de Dépôt versus Ferroligas. In this case, a bank gets an order seizing certain silicon in Louisiana. Now, there's no question that the shipper owed money, and there's no question that the silicon was originally given as collateral to the bank. Nevertheless, the bank seized the collateral, but did not have access to the document of title. So the Swiss bank that seized the goods without seizing the document of title was not entitled to the goods. What the court said is that the party that controls the documents controls the goods. Therefore, if Banque de Dépôt wanted to go after those goods, what it had to do was to track down the document of title and seize that document of title, not seize the goods themselves. Now, in order to negotiate a document of title, if it's an order instrument, which is to say it's referenced as paying to the order of, then the good faith purchaser must take it by endorsement, meaning the transferor must sign the document and deliver the document to the transferee. The carrier has some liability issues here, although pretty minimal actually. The carrier is only responsible to deliver the goods to the holder of the bill of lading. That if a carrier delivers the goods to someone other than the holder of an original bill of lading, then the carrier could be liable for misdelivery. Now, in this section, we talk about documented collection. That's the process by which documentary sales are ordinarily conducted. It's the process by which the banking institutions are going to serve as intermediaries between the seller and the buyer. In a documentary sale, what's going to happen first is that the buyer is going to arrange financing from its bank. And once it arranges that financing, the bank will send to the seller a document called the letter of credit. And what the letter of credit is assurance to the seller that the buyer has sufficient funds with which to purchase the goods. Once the seller receives the letter of credit, then the seller can give the goods to the shipper, to the ocean carrier, and in exchange the carrier will provide to the seller that document of title, the bill of lading. At that point, the goods are placed in the hands of the shipper, the carrier. The carrier is going to take the goods and start to transfer them. Now what the seller will then do is transfer the bill of lading to the seller's bank. And the seller's bank will then provide that bill of lading to the buyer's bank. The buyer, because he now has financing, will have a chance to inspect the goods, and once the buyer has inspected the goods, the buyer will give payment to the buyer's bank. The buyer's bank will then transfer that payment to the seller's bank, and eventually it will work its way to the seller. In the meantime, the buyer, now that it has the bill of lading, presents that to the shipper, and the shipper, the carrier, will provide the goods to the buyer. Now I've got an animation on this on D2L. I would advise you to look at that. It's a little better explanation of how this process works. Now, the last topic we're going to talk about is allocating shipping responsibilities and what's called the risk of loss. The question in a documentary sale is who bears the risk of loss at which point, meaning if the goods are lost, who bears the risk of that loss. Now, ideally, the seller wants to be free of the risk of loss as soon as the goods are out the door. The buyer does not want to take on the risk of loss for as long as possible. So the buyer would like to delay the passing of the risk of loss for as long as possible. So that's why there needs to be some sort of negotiation up front. And usually the ability to negotiate depends on the relative bargaining positions of the parties. If the seller's products contains superior technology, or if they are commodities in short supply, or patented products that the buyer needs, then the seller may be in a stronger position to shift the risk of loss to the buyer. Similarly, if the buyer is in a dominant economic position, such it will be more able to dictate the terms of the shifting of the risk of loss. Now, allocation of the risk of loss usually depends on whether the contract is what's known as a shipment contract or a destination contract. If the contract calls for the seller to ship the goods by carrier, but does not require the seller to deliver the goods to a specific party or place, then it's what's called a shipment contract. And most contracts are, in fact, shipment contracts. In a shipment contract, the risk of loss passes to the buyer when the goods are given to the first carrier, whether that's a truck, an airline, or an ocean carrier. And shipment contracts are the norm in international trade. Most contracts are shipment contracts. Now, destination contract, in a destination contract, the risk of loss passes to the buyer only when the goods are tendered to the buyer at the point of destination. This could be a particular city or even a specific place of business. And if the contract calls for the seller to deliver those goods to a particular destination, it's a destination contract. And if the contract is silent as to when the risk of loss shifts, in a destination contract, it shifts when the goods are tendered to the buyer at the point of the destination. Now, the CISG contains provisions regarding risk of loss. According to Article 66 of the CISG, again, unless the parties agree otherwise, any loss or damage to the goods which occurs after the risk of loss has passed from seller to the buyer does not relieve the buyer of his obligation to pay for the goods, unless the loss of damage is the fault of the seller. So once the risk of loss passes, then the buyer's obligation to pay for the goods, regardless of whether it obtains the goods or not, remains in place. Now, if it is a destination contract, we said that the risk will pass to the buyer at that place. So if the seller is required to deliver them to a specific place, the risk of loss is not going to pass to the buyer until the goods arrive at the buyer's particular destination. Now, we mentioned earlier that there are certain standard trade terms called Incoterms. The Incoterms are put together by the International Chamber of Commerce in Paris. The terms are designed to cover these matters having to do with delivery and risk of loss. Now, there are a number of three-letter abbreviations that are used. Probably the most common would be FOB, which stands for free on board, or CIF. CIF stands for costs, insurance, and freight. Both of these types of contracts are shipment contracts, and what it means is that the seller fulfills his obligation to deliver the goods when the goods are delivered alongside the ship that is going to carry the goods. Now, the initial CIF indicate that the price of the shipping of the goods is going to include costs, insurance, and freight, meaning the seller will insure the goods for loss as it puts them on board, but because it's a shipment contract, the seller doesn't actually bear the risk of loss. That's borne by the buyer. But in order to minimize the risk of loss, the seller provides insurance. Those are two of the common phrases. There's a number of them. There's 16 different possible combinations. However, for our purposes, we're only going to talk about FOB or CIF. So what do we learn in this lecture? We learn that transaction risks include delivery risk and payment risk. The documentary sale permits parties to conduct business at great distance. We learn that the CISG contains provisions regarding allocation of loss. And finally, we learned about a standard set of trade terms called Incoterms.